The subcommittee will come to order without objection. The chair is authorized to declare recess at any time. We welcome everyone to today's hearing on agency, adjudication, and other agency action. I will now recognize myself for an opening statement. In today's hearing, we will address how some federal agencies bring enforcement actions against defendants before the agency's own in-house courts. This practice, when federal enforcers sue defendants but bring the case before the agency's own judges instead of before an Article III court, raises a number of concerns. In addition to considering these concerns, we will have the opportunity today to explore ideas for reform. Stepping back, the administrative state is made up of numerous federal agencies. A number of these federal agencies have the power to sue defendants to enforce the law, and the agencies can choose where to sue, in-house or before an Article III judge. There are significant differences between facing an agency in an Article III court and facing the agency's own in-house adjudicator. For example, a number of federal agencies make their own rules of procedure and evidence. These rules can differ from agency to agency, and they differ from the rules used in Article III courts, sometimes in ways that work in the agency's favor. Often, administrative law judges preside over these cases, and unlike Article III judges, administrative law judges are hired and paid by the same agencies that bring the cases before them. Today, we can examine whether these judges are truly independent of the agencies that employ them. Also, unlike in Article III courts, when an agency sues a defendant in an in-house court, the defendant lacks access to a jury, a right the Seventh Amendment protects. Think about that. If the agency wants to opt for a jury trial, it can, but the defendant, whose rights are at stake, cannot. These and other concerns create a risk of perceived institutional bias, that the deck is stacked against the defendants. The risk of perceived bias is made worse by the extraordinarily high number of cases won before their own courts. Because the agencies play by their own rules, it is easier for them to get preferred outcomes. Finally, there's arguably a lack of fairness and due process in some of these cases. Defendants are often unable to seek interlocutory appeals on evidentiary and other procedural rulings. The effect is that defendants with limited resources face long odds of success and prolonged and costly challenges from agencies. This imbalance allows agencies to force settlements through exhaustion and can be a way for agencies to avoid judicial oversight from a truly independent adjudicator. To add insult to injury, when defendants settle, some agencies use gag orders to prohibit defendants from discussing their matter critically. There's a serious lack of transparency in administrative adjudication. It undermines confidence in the legitimacy of the proceedings and ultimately in the justice system. Today's witnesses are leading scholars and practitioners with significant knowledge of this subject matter. I look forward to hearing from our panel of expert witnesses and discussing these important items. I now recognize